Luigi Mangione exploded in court. 2 prosecutions for 1 incident. That's double jeopardy. And if you're watching this at home, that probably sounds right. 2 trials, 1 killing. How is that not being tried twice? But this case does not turn on instinct. It turns on something most people don't even know exists. New York has its own double jeopardy statute, and it's broader than federal law. That's where this fight actually lives. Now let's tune in to the story. Mangione faces a New York State murder charge. That's the life exposure case. Separately, federal prosecutors have charged him with interstate stalking and firearm offenses tied to the same killing. 2 separate systems. But here's the wrinkle. New York State criminal procedure law does not fully embrace the federal dual sovereignty doctrine. Under New York State's statutory double jeopardy protections, if a defendant is prosecuted first in federal court for the same criminal transaction, the subsequent state prosecution can be barred. Not always, but often. That's the lever. The prosecution case. Why the state moved fast? State prosecutors push for an earlier trial date. Why? Because if the state goes first, the statutory bar disappears. So if the state secures that conviction first, there is no double jeopardy shield. The defense cannot argue then that New York statute blocks the case. So from the state's perspective, this is not about arithmetic. It's about priority, and they argue they have it. Let's discuss the defense case. Strategic gamut. The defense position is not irrational. Federal stalking is narrower than murder. Shorter trial, different elements, possibly easier to defend. So it should go first as a practical matter. If the federal jury returns a verdict first, the defense then can argue, under New York law, the state cannot prosecute the same criminal transaction again. And so, no life sentence for murder. Even if that argument ultimately fails, it becomes a preserved appellate issue. And appellate leverage matters in life exposure cases. So when the judge ruled the state trial proceeds first, Mangione reacted because that ruling stripped the defense of its strongest sequencing weapon. Now the cross-examination, where the strategy hardens. Let's test this carefully. Is New York statute broader than the federal double jeopardy doctrine? Yes. Does it fully eliminate dual sovereignty? No. There are exceptions, and courts interpret same criminal transaction carefully. But here's the tension. If the federal trial goes first and ends in an acquittal, the defense argument becomes stronger. If it ends in a conviction, the state still faces statutory challenges. So the sequencing fight is not symbolic. It's material. This isn't even about avoiding 2 trials in theory. It's about triggering a statutory shield, and that's why the state pushed to the front. Let's discuss the law. The U.S. Constitution permits dual sovereignty prosecutions, but New York's criminal procedure law offers broader protection. It can bar a second prosecution arising from the same criminal transaction, even across dual sovereign lines. That is the battleground, not the Fifth Amendment double jeopardy alone. Here's my ruling. Under federal constitutional law, dual sovereignty allows both prosecutions to proceed. But under New York's broader statutory protections, sequencing matters. That is why the defense fought so hard over which trial is going to start first. And now that the state murder trial has been set for June 8th, the defense's leverage has narrowed. But it hasn't disappeared completely, because preparation arguments, readiness arguments, and appellate preservation arguments can still shape how this fight unfolds. This is not a one-motion fight. It is a positioning fight. And when life exposure is on the table, positioning never stops. So no, this story does not end with a scheduling order setting the trial for June 8th. It moves to the next battleground. In criminal litigation, position is power. If you want clear legal analysis on real cases before the outcome, subscribe. See you in the next case.